The financial crisis of 2008 greatly enhanced the role of compliance in financial firms' effort to manage risk of wrongful conduct. But much of the ground was prepared in the preceding decades. The topic is of considerable importance to the banking industry. From 2008 to 2017, according to the Boston Consulting Group, banks globally paid $321 billion in fines to financial conduct regulators. Compliance plays several key roles in building a compliance program and in managing the risk of potential government prosecutions. These roles fall within two main categories: the role of compliance in preventing wrongdoing and its role after wrongdoing has been discovered. First, I'll explain why compliance has assumed such an important role in today's corporation. An important watershed was the Caremark decision, a 1996 Delaware State Court case. The court said that a board of directors can incur liability to shareholders if it does not make a good faith effort to monitor the risk of their employees' violation of applicable law and regulation. According to Caremark, the board had to ensure that a reasonable information and reporting system was in place. In other words, an effective compliance program. The Caremark decision had a widespread impact throughout corporate America and its boardrooms because Delaware is host to half of the largest publicly traded firms in the US. In addition, compliance in legal practitioners, boards of directors, and senior executives view Delaware judicial decisions as the leading precedent on corporate practices due to their high level of predictability and the quality of their legal reasoning. Moreover, companies are strongly incentivized to establish compliance programs because they can reduce criminal sentences, fines, and probationary conditions. Under the US sentencing guidelines for business organizations, companies gain sentencing credits if a company has an effective compliance and ethics program. The guidelines' main relevance is in settlement negotiations, since the vast majority of investigations end in settlements rather than court litigation. For its part, the Justice Department will forego harsh settlement terms in plea negotiations if it finds that the defendant company's compliance program was robust, even when serious criminal wrongdoing has occurred. Another motivation for creating strong compliance programs is the rise of the regulatory state in the US in the latter part of the 20th century. The proliferation of laws and regulation has exponentially increased federal and state criminal and civil corporate prosecutions. The obvious byproduct is a focus on corporate compliance in the US and even abroad for foreign firms with US operations. Companies have expended considerable resources to create compliance systems that will help detect and prevent employee wrongdoing. All of these developments have buttressed the powerful role of compliance in addressing future and existing wrongful conduct. Now let's turn to the preventive role of compliance. Compliance's central function is to understand the key risks in a firm's business operations and to design appropriate policies and procedures. It creates these policies and procedures in collaboration with risk management and operating business lines to ensure preventive controls are in place in order to control these risks. In this role, compliance not only has Caremark and other Delaware opinions as guidance, but also DOJ guidance for its prosecutors, the precedent of DOJ prosecution agreements, and the US sentencing guidelines. The Justice Department has issued extensive guidance on effective compliance programs and how they can mitigate corporate criminal liability. Compliance has an equally important role in protecting the interests of a company after wrongdoing has occurred. If such wrongdoing is egregious, the government will inevitably uncover it, either through its own investigation, by a whistleblower's complaint, or through the company self-reporting to the government. At that point, compliance can help to minimize the compliance risks from civil and criminal prosecutions by the DOJ and prosecutions by regulatory agencies such as the SEC and the CFTC. First and foremost, the company should initiate its own investigation when it learns of wrongdoing before the government starts its own investigation, if any, and self-report its findings to the government. Compliance is a key player in conducting internal investigations in collaboration with in-house and outside legal counsel. Ideally, senior management and the board will view an internal investigation as an opportunity to make meaningful remedial changes by acting on the compliance weaknesses uncovered by whistleblowers and internal investigations. Compliance takes the lead in remediating compliance policies and procedures, which can then gain sentencing credits. Compliance plays a critical role following a government investigation. If a company has established an effective compliance system in the first place, the firm will likely gain credit under the sentencing guidelines and under DOJ and SEC enforcement policies. Compliance is in an ideal position to highlight the positive features of the compliance program in negotiations with the government. And if robust compliance was absent, compliance also plays a critical role in crafting a remediation program that may help to mitigate criminal or civil penalties during plea negotiations. In sum, compliance plays critical roles in cases of employee wrongdoing, both before and after government investigations and prosecutions.